Good morning, everyone. Today is another Sunday live about the latest news in immigration world. And also, if you have any questions, I'd be more than happy to answer those questions. Just to introduce myself, my name is Al Parsai. I'm a regulated Canadian immigration consultant with 10 years of experience as an immigration consultant. I hold a Master of Laws degree from York University, which is one of the best law schools in Canada. I also hold another master's degree. I have had clients from 50 plus different countries, and our office is located in downtown Toronto, and we have represented thousands of people in different application types, from inadmissibility issues to express entry to family sponsorship to study permit, work permit, you name it, we have done it. And I'm the author of 88 Tips on Immigration to Canada, which has been identified as a bestseller book a few times by Amazon.ca under the immigration law books. So, what I'm going to do today, I'm going to review the latest news that we have published on settler.ca, our official website. And then after that, if some of you have some general questions about immigration to Canada, I'd be more than happy to answer those questions. Please post your questions in the chat area. You don't need to repeat your questions when I'm done with reviewing the news, which is probably takes about 15 minutes or so. Then I'll come back and answer your questions. So the big news that I would like to share with you is the fact that the government of Canada made some significant changes in terms of the way they process work permit applications for the spouses of those people who are in Canada on a temporary basis. So, for example, if you are here in Canada as a worker or as a student, and then your spouse or common law partner wants to move to Canada, then you could apply, and you still can apply for a work permit for your spouse or common law partner based on your work status in Canada or your study status in Canada. The changes mostly focus on the relationship needs to be genuine. So they don't want to see somebody has received a work permit in Canada or a study permit in Canada, and they suddenly get married to somebody, and that person tries to come to Canada. So you just want to make sure that the relationship is not for the purpose of getting status in Canada. Keep that in mind under Section 4 of the immigration regulations, which is also, this section is called bad faith. If somebody gets married to another person or enters a common law relationship or a conjugal relationship primarily for the purpose of gaining status in Canada, that person is not considered a family member. And IRCC on September 27th wanted to emphasize on this issue and remind everybody that if you are a temporary foreign or common law partner or your spouse move to Canada as a open work permit holder, you want to make sure that or you need to present enough documentation to convince the authorities that this relationship is genuine. Now, of course, you need to look at the relationship. So the relationships that are usually more than 2 years old, you could consider that this is a genuine relationship. It started long time before even you thought about moving to Canada as a temporary foreign worker or as an international student. Or if you have children together, then that clearly shows that the relationship is a genuine relationship. But for those cases that they don't have children and the relationship is under 2 years And this is something that I personally advise, that you need to prepare enough documentation and present enough documentation, such as support letters from family members, pictures of you going out with each other, financial support of each other, those kinds of things, just to convince the immigration authorities that the relationship is real. So that's the big change. And of course, there are some elements of IMPC 41, which is for open work permit for the spouses of temporary foreign workers, or IMPC 42, which is open work permit for the spouses of international students, that are there's subtle changes that have happened here and there. Some of those changes are not subtle. For example, one of the things is that if you are an international student here, your spouse or common law partner could receive an open work permit only if the program that you have registered to is qualified for postgraduate work permit. Otherwise, you cannot even apply. So I'm going to publish some articles about IMPC 41, C42, bridging open work permit, and all those changes that are made on September 27th. I will publish that very soon. We also want to know about the statistics. So Canada welcomed 74,353 immigrants during the second quarter of 2021. So the number is still far away from the numbers that the government was targeting. Because if you recall, the government said that in 2020, we didn't have enough number of immigrants. So in 2021, we will invite 400,000 immigrants to Canada. But if you roughly say 75,000 times 4, and the pace would remain the same in quarter 3 and quarter 4, then we're roughly looking at 300,000 immigrants, or maybe even less. So I'm not sure if the government will be able to reach the targets that they have in mind, but still they are trying. I just published the link here. You can also visit our website. We have published this news. So during the second quarter of 2021, Canada welcomed 74,353 immigrants. This is the highest number for a quarter since the pandemic began. So as you can see, that was the number 1 on the list. Statistics Canada reported on September 29th that this increase is in line with the recovery seen during the first quarter of 2021. However, the amount of immigrants is still lower than the second quarter of 2019 before the pandemic. Canada saw a net increase in non-permanent residents. So we had actually an increase of 12,559 during the second quarter of 2021. The net increase was mainly due to additional work permit holders. So there are more work permits being issued. I actually see this among my clients. According to the report, all provinces welcomed more non-permanent residents than those who left, except for Alberta. Another interesting fact is that the number of people who moved to another province or territory in the second quarter of 2021 was the highest for a second quarter since at least 1972. Ontario lost 11,857 immigrants. Manitoba lost 3,613, and they had the highest net losses to interprovincial migration. Saskatchewan was also in the negative. Alberta was in the negative. Northwest Territories and Nunavut also reported negatives. The report says that British Columbia, Nova Scotia, New Brunswick, Prince Edward Island, and Quebec saw the highest gains for interprovincial migration for a second quarter since at least 1972. So it looks like that people are also trying to move from one location to the other location, hoping for better lives during pandemic. The news that our journalist has published is Liberals to remove some grounds the immigration department uses to exclude applicants. According to the local media, the Liberals are planning to remove nearly all grounds for immigration used to exclude applicants. This means that Canada will be more open to immigration to Canada. And of course, the report initially was issued on Toronto Sun. And if you know Toronto Sun, you know that the way that things are not in line with the way that usually liberals perceive things. But it's interesting to see our take on this issue. Again, you can visit our website and take a look at our journalist points about these changes. And Gurpreet, I will take a look at your question as soon as I'm done with the news. So the other question that we've been asked constantly is that, can my parents travel to Canada if they do not qualify for fully vaccinated travel exemption? So the simple answer is yes. However, you need to keep that in mind, that how this works. So if you are a permanent resident of Canada, or if you are a Canadian citizen, and then your parents want to travel to Canada, there are two scenarios. One of them is that they are fully vaccinated. If they are fully vaccinated, then considering that fully vaccinated people can travel to Canada since September 7th, 2021, then there is no issues. They can just, if they have, of course, a temporary resident visa or ETA, depending on their nationality, then they can easily travel to Canada. However, if you are dealing with parents that they hold visas to Canada, but they are not fully vaccinated, in that situation, when they reach Canada, they need to self-quarantine for 14 days. They need to go through extra testing. They will be monitored during their first 14 days here in Canada. But since they are immediate family members, you don't need to apply for travel exemption for them. What you need to do is you need to prepare proper documentation that they show the relationship between you and your parents, your status in Canada, a letter that explains why they are traveling to Canada and their quarantine plan. And of course, they need to install ArriveCan and answer all necessary questions on ArriveCan. And my point of my advice to you is that they also need to get in touch with the airline, present all their documentations, and make sure that they meet all their expectations by the airline, because airlines are also in direct contact with immigration authorities in Canada. And in case something is missing, they may prevent you from boarding the plane. So make sure that you do that. This is different for brothers and sisters. If your brothers and sisters are not fully vaccinated, they are considered extended family members. And this means that they have to get an exemption. And the process for exemption nowadays takes more time because of the current situation that Canada is moving towards fully vaccinated people. Okay, so the last piece of news that actually two pieces of news, and then I'm done. So the Express Entry actually, again, invited only PNP candidates. So it looks like that they turned away from even inviting Canadian experience class. We were hoping that they add federal skilled worker, and now in September, we only had one invitation for Canadian experience class, and they only invited 2,000 people. And actually, the minimum score was increased to 462. In terms of PNP, they recently invited under Express Entry 761 PNP candidates, and these are people who are selected by the provinces. And actually, talking about provinces, we had a few provinces that they were active in terms of inviting immigrants to Canada. Now, we have posted some of the statistics on our website. You can visit those statistics or see them by visiting this link. But these are a couple of provinces. So British Columbia invited a total of 422 immigrants. 386 of those were invited on September 28th, 2021. And they were invited under these groups: skilled worker, under International Graduate Program or SI entry level, and semi-skilled workers, again, skilled international entry level and semi-skilled and skilled worker, express entry BC, international graduate, express entry BC. And minimum score, depending on the category, varied from a minimum of 69 to 86. And then on September 28th, 2021, they also ran another 36 of invitations under skilled worker international graduate, EEBC, skilled worker international graduate, and the minimum score was 105. Saskatchewan on September 27th, 2021, again invited some people, and a total of 391 people were invited under various Saskatchewan program, mostly under occupations in demand, and also some under express entry. The minimum score was 71. For those of you who are familiar with Saskatchewan, you know that 30 points out of 100 points belongs to some sort of association with the province. And when the minimum score is 71, it means that nobody who had no association with the province were selected. And by association means, like, for example, you have worked or studied in the province. Manitoba on September 23rd invited 650 people, and the number of letters of advice to apply was 529. Ranking score was 401, and under the skilled workers in Manitoba, and another 54 invitations under international education stream. And that's how we also had some invitations under skilled workers overseas. That's how we had a total of 650 invitations. Alberta was active on September 14th and September 21, and they invited a ton of people. Actually, on September 14th, a number of notifications of interest letters was that was sent was 385, and on September 21st was 450. So that's pretty much wraps up. Of course, we have more news on the website. I encourage you to read the articles on our website. You can just visit settler.ca, and on the menu, click news, and you will find the latest news. Okay, so we have a couple of questions here as well. I answered those questions, and I talk about, if we have some time, I also want to talk about misrepresentation. So Gurpreet Singh Antal says, sir, any updates regarding pending application of FSW? We are waiting for the last 17 months. So unfortunately, not much. What I can tell you is that finally, in the past 2 weeks, I have seen some movements from the visa offices in India. Some of my clients received their medical forms. There were a couple of email correspondences with New Delhi and us, and that's a glimpse of hope. So it shows that they are activating their offices. I don't know how far they are going, but at least not to the point that I feel confident and tell you, yeah, everything is back to normal. Definitely not back to normal, but at least some movements, because they were fully silent up until, at least for me, up until a couple of weeks ago. So there is hope, but when, Gurpreet, this will happen and when they will actually start processing your application, I don't know. So AJ says, hi, sir. When is the best time to order GCMS notes, considering they take 30 days to reply once ordered? Basically, can I apply in 2 months after AOR? So AJ, in terms of ordering a GCMS records, you can do it at any point of time. It has nothing to do with your application. In fact, the GCMS records are issued by another department. So there's a department dedicated to ATIP requests, and ATIP stands for Access to Information and Privacy. So that department will take care of GCMS records. Having said that, I see nowadays a ton of unnecessary requests for GCMS. You need to understand why you're ordering GCMS records. GCMS records is not necessarily a good way to find out what's going on with your application, because let me tell you what, if they do not communicate with you, simply it means that they are not processing your application. And if you ask for your GCMS records, it will not speed up the process of your application. As I mentioned, the entity that deals with ATIP requests is another entity. So it's like your application. I give you an example. It's like that your application is in the visa office in Warsaw, and then you order GCMS records in the office in Ottawa, and you're hoping by ordering the GCMS records from the office in Ottawa, the office in Warsaw, which is about 7,000 kilometers away, will somehow magically decide to process your application. So keep that in mind. Now, I'm not going to deny that ordering or submitting an ATIP request will trigger the system because somebody is asking questions about that application, but that triggering the system does not necessarily mean that they will start processing your application because you asked for information. I said all of those, but there is absolutely no limitation or no major consequences because you order GCMS records. So if they don't affect you positively, they also won't affect you negatively. It's just information requesting. So yeah, you can basically order this at any point of time. So the other question is from Hiran Patel. Canada Embassy in India has started to work in PR application, when in India to start biometrics in self-employed, as I got permanent file number on March 2020. I got file number in self-employed in March 20. Now, how much time CIC will take? Okay, so generally speaking, this is the process for self-employed applications. First, you submit our application to Central Intake Office in Sydney, Nova Scotia. An officer will initially process your documents, take a look at your documents, compare them to the document checklist they have. And if they believe that your application is complete, then they will issue a file number. And we're talking about those people who have received their permanent file numbers. Because you're talking about March 2020, it's very likely that you have received your actual file number. So they will issue the file number, and then they transfer the package by mail by snail mail. They usually put them in these large bins, and then they will ship them to the visa office responsible for your country of residence, which in your case, it looks like that it is India. And then they will just stack them, sort them, and then it will be a long waiting time. So in the past, at one point, the processing time for for a self-employed class had dropped under 2 years. Actually, I had some clients that they were processed even in a few clients. Sorry about that. We had a connection issue. So we have some clients that they are waiting for being processed for more than 3 years, believe it or not. So unfortunately, the processing time, even the official processing time, has reached 34 months or so. But in reality, your processing time could be way more or way less. So nobody can predict the future, but I don't know when, considering that coronavirus has delayed everything. So Asibullah Amani, hello, and politeness. My wife did my sponsorship work, and I did it without power and medicine. Now she informed me that I do not accept my marriage. What should I do? So first of all, I'm sorry about hearing what's going on. Obviously, I cannot comment on an application that is not mine because I don't know the specific. And obviously, I cannot offer immigration advice online, but I will tell you the generic answer to this question. So the generic answer to the question is that the sponsor has full power in a sponsorship application for as long as the person has not become a permanent resident of Canada. So if I sponsor my spouse to Canada at any point of time, before my spouse lands in Canada, I can withdraw. And as soon as I withdraw, the application is over and that spouse will not be processed. And there is no way for that spouse to gain the trust and approval from the immigration authorities, because they were being sponsored and then suddenly sponsor backed off. The only, I would say, exception could be under humanitarian and compassionate considerations, that something extraordinary, and I must emphasize, something extraordinary happened that you could justify the situation to immigration authorities. But generally speaking, I would say if the sponsor says no, it's over. Even if the applicant is at the airport, just waiting in line to land, and the sponsor calls CBSA at the airport and says, I'm withdrawing my application to sponsor this person, CBSA will not allow that person to enter Canada. That's how powerful sponsor is. But as soon as the person lands in Canada, then their sponsor cannot do anything. And by landing, it means that the applicant becomes a permanent resident of Canada. So Heron says, interview is compulsory coming in self-employed process? No. So it depends on the office that processes the application. In the past, I've seen the visa office in Singapore, they pretty much always interviewed people, or at least in case of my clients. But with other visa offices, the only other office that I remember that's almost guaranteed that they will interview is the office in Beijing. But many other offices, they don't really interview self-employed people, like Ankara, Warsaw. I haven't seen many interviews in other offices. So it's up to the immigration officer whether to interview or not. They can definitely, regardless of the visa office, they can interview people, but it's not that common. Sometimes they do, sometimes they don't. But if you want us to look into your application and come up with advice, you can book an appointment with me, and we can look at that, and we'll tell you whether it's necessary for us to take over your application or not. Because some people, they think they qualify for self-employed cases, but they do not really qualify. And we've had many cases that they were confident and they approached me, they booked an appointment with me, or they filled out our assessment form and we realized that they do not qualify. Or maybe they qualify, but the kind of application package they have prepared does not fit the expectations of the immigration authorities. So Lena Gluckston sent application for proof of citizenship last November. My father born in Canada. Application complete. Can I check on my status? So again, I don't know about the specifics of your application, but you can check out check the status of your application if you have an application number. And if you don't have an application number, then there is no way that you can check the status. And how do you receive the application number? They actually issue a letter called AOR, Acknowledgement of Receipt, and they tell you that they have received the application, and there is a number over there. And from that point, you can check out the status of your application on the ECAS system, or you can call them if you're inside Canada and ask them directly, or you can submit a web form and request about the status of your application. So that's the general idea behind it. But I can tell you that for certificate of citizenship, the processing time before COVID used to be 5 months. But after COVID, as you can imagine, it has elongated significantly. I had a case that it took almost 2 years for them. 2 years is too much, 1.5 years. It took them about 1.5 years before they actually issued the certificate of citizenship. But when you have the numbers, you can obviously follow up with them. So the next question is from Ejnab Romero. Good day, Parsai. My Outland family member just had her medical and found out she had medical condition that needs treatment for 6 months. Could immigration wait for the result until she is cleared? So obviously, again, I cannot offer immigration advice, But I think this is one of those cases that you definitely need to get in touch with a professional to analyze the situation for you, and based on that, communicate with the immigration authorities and request adjustments. If you don't do that, then and of course you can do it yourself, but at the end of the day, if I'm generally speaking, yes, is there a possibility to negotiate matters? Yes. In the past, I've had cases that we put off processing of the application. Of course, we communicated with the immigration authorities, and the immigration officer agreed to postpone the application for a few months. And then, when my client was cleared, she went through the medical exam again, and everything went well. But we have to you need to get in touch with a professional who is familiar with the medical inadmissibility and ask for help. It's up to you, but and I'm not saying you are obliged to hire me. If you want to hire me, obviously I have dealt with these kinds of situations before, but you just consult with somebody who is a professional in the field to help you. So the next question is by Sapphire. Hi, does Lonely Canadian still apply? I would like to sponsor my nephew. I am 52 and have no family here in Canada. I have had cancer and now well, but do need somebody with me. My nephew is 22. Follow up, both of my parents are deceased and siblings are not interested to come here. So generally speaking, yes, if somebody has nobody in Canada, or outside Canada, that they aren't in line for sponsorship, or they are already Canadian citizens or permanent residents, then yes, that person may sponsor any family member they choose. The issue that you need to keep in mind, though, is that you need to prove to immigration authorities that that's the case, and also the humanitarian aspects of that. If you're interested, I have clients of this nature, and you probably have seen my articles about sponsoring nephews and nieces to Canada, sponsoring uncles and aunts to Canada, sponsoring siblings to Canada, and you can book a consultation session with me. We can review the case, and if we find that this is something that you want to know, then this is something that you can do, then you can move forward. So for those of you who are live, I post a link on the chat box. This gives you 20% discount on your consultation session. I'm not going to post it below this video. This is only for those people who are currently live. So before we wrap it up, because the questions are over, obviously if more questions come in, I will answer them. I just want to remind everybody about misrepresentation. Be careful with misrepresentation, because so many people approach me with the misrepresentation issues. Thank you very much, Sophia. So misrepresentation, it means concealing information from the immigration authorities, or altering information for immigration authorities to gain a status in Canada. So that means not disclosing important things. So we are talking about material facts, things that affect the decision-making of the officer, not sharing those or making changes to those. If you do that, then you become inadmissible to Canada for 5 years. And that causes lots of trouble, because within those 5 years, you cannot apply for immigration to Canada. Your applications for temporary status will be refused, etc., etc. Unless you somehow clear it by, if you're inside Canada, receive a removal order, apply for an ARC or authorization to return to Canada and resolve this issue if they accept. Or if you have applied outside Canada, apply for a temporary resident permit to be able to travel to Canada. And these are it has consequences. They are very expensive. You need to hire professionals like me. It costs you a ton of money. So be careful when you are filling out the forms. Don't miss any key information. One of the things that I constantly see is that people, visas get refused from the United States, and they don't disclose it to IRCC. Let me tell you this: Canada, the United States, New Zealand, the United Kingdom, Australia, they share information, immigration information from each other. So if you have a refusal of visa from any of those countries, make sure that you include in your application that you had a refusal. Any other countries, not just them. And just being refused from another country does not mean that Canada will refuse you. So be truthful to avoid problems. Okay, two more questions are here. Can you also talk about finalization of FSW application pending from 2020, whatever information you have? Jimmy, unfortunately, I talked about it, but unfortunately, there's not much going on because most of the visa posts are either closed or they do not work properly. Like I have applications stuck in New Delhi. I have applications stuck in Sydney, Australia. I have applications stuck in Ankara. I have applications stuck in Warsaw and some other visa posts out there that I don't even remember right now. And the message is the same when you communicate with them. Either they won't respond, or if they respond, it's just a generic response that says, oh, we only deal with essential applications. So unfortunately, right now, I cannot say anything beyond that. I wish I had a better answer for you. So Manmeet Singh says, hello, Al. I was your student. Oh, hi, Manmeet. And Ashton, I have a quick question. What if someone forgets to mention his previous refusals in PR application by mistake? What would be the best solution? So look, there are two stages. One stage is before receiving a PFL or procedural fairness letter. The other is after PFL. So if you have not received a PFL and you clear this and you explain to them what happened, this was a mistake, and inform them, then the chances that the officer will go in the direction of misrepresentation are way lower because you have come clean and you have explained this. I'm just dealing with a refugee application case, and my client had failed to talk about a refusal to New Zealand. And while I was interviewing them, I realized that. And what we did, we prepared a document. We explained to both IRCC and Refugee Protection Division that this is the case. They are most of the time, if it is before receiving a procedural fairness letter, they are flexible. It's unlikely they refuse the application mandate. But if it is after procedural fairness letter, it's very difficult to get away from misrepresentation because at that moment, the officer has come to the conclusion that you were not truthful. However, sometimes we have the chance to negotiate with them, explain what this mistake happened, or request withdrawal of the application. So sometimes they agree, but in most of the cases, they won't agree and they issue misrepresentation regardless of what your documents present. So let's say, and I'm just making this statistics up, but just to give you an idea, if you have not received a procedural fairness letter and you identify that some key information was missing from your application or some documents were altered, whatever, and you come clean, then there is a 90% chance that they will accept and they forgive you. But if it is after receiving the procedural fairness letter, and no matter how hard you try, there's 90% chance that they won't accept. Again, these numbers are not correct. I'm just trying to tell you that how difficult it becomes when you receive a procedural fairness letter from an immigration officer. So be careful with that. Good question. Conroy Pinnock, sir, I live in Canada for 3 years. And whenever I see CA, I think of California. In Canada for 3 years, get married. My status did change in time. I get 1 year's ban, can return without the sponsor me. So I don't know the exact specifics of your situation, Conroy. I just posted a link to an offer that you can get 20% discount on consultation fee with me. If you are interested, you can book a consultation session with me. But generally speaking, if somebody has received a 1 year ban, which is an exclusion order, after 1 year is passed, then they can travel back to Canada. Now, depending, of course, on their nationality. They probably need an ETA, or if they are US citizens, they don't need anything, or sometimes they need a visa to come back to Canada. But the actual exclusion order will be ineffective after 1 year ban. But if you want to come back within that 1 year, then you need to apply for authorization to return to Canada. However, realistically speaking, nowadays an ARC application could take more than 1 year to be processed. So it's basically useless to apply for ARC. It's better to wait for 1 year to be over. Sapphire says, hi, Sarah, I'm from Ontario. Where is your office? Our office is in downtown Toronto. We are at the intersection of Queen Street West and Bay Street. We are actually at Sheraton Center. And if you look up Parsai Immigration Services, you will find our office. We are in a very nice location. I'm not gonna lie to you, but I will just post the link here. You can also find us on Google Maps. Okay, thank you very much for attending this session. Thanks for the great questions that you posed and listening to me while I was talking about the news. I will come back next Sunday at 10 a.m. Eastern time or Toronto time, and hopefully we'll explore other options. During the week, my intention is to publish some articles about spousal work permit applications, etc. So thank you very much. Oh, that's great, Sapphire. We hope we can see each other. Nowadays, because of Corona, most of our clients, they do not show up in the office. But if you want to come to the office, by all means, you're more than welcome. Okay, thank you, and see you next week. Bye.